From the very beginning, there didn't appear to be a very broad-based examination of the other possibilities.
From day one, he was the suspect. He was the only one they really ever thought about as having committed this crime.
He is innocent. He was with me that morning. You know, he didn't do this crime. We went into town. We saw all these people.
He's at least entitled to a good faith effort on the part of the prosecution and the defense to give him a fair trial. I don't think Mr. Freeman got that.
The prosecutor put out massive displays of weaponry, none of which were mine, you know, but gave the illusion that they were mine. There were electronic listening devices. He had a parabolic microphone, ninja magazines, there were swords, knives. These were all on the prosecution's table sitting in front of the jury during the course of the trial.
The cops cheat, the prosecutors can cheat, people cross the lines, the crime labs are allowed to get away with shoddy or completely fraudulent work.
There were ninja stories and you know, secret rendezvous at the waterside and jumping out of trees. I mean, it was, you know, it was insanity.
This prosecutor did a heck of a job persuading this Port Huron jury that this drifter from Flint came up there and killed one of their people.
He's very good at manipulation. I believe he's manipulating you if you believe that he's not guilty.
As of November 13th of last year, I've been in prison for 20 years. So I'm going on my 21st year now.
I lost complete faith in the judicial system. I thought it was sort of a mockery of everything I always thought that the court system was about. I thought that the guy got railroaded.
I can't believe they would keep anybody in with that kind of a trial. It wasn't really a trial, it was a show.
All they had was circumstantial evidence. Somebody who kind of maybe sort of vaguely looked like Fred at the scene, but no identification.
For the prosecution, their whole case really depended on basically two things. One was the so-called eyewitness, a young man who was standing in the parking lot at the community college talking to a friend. They heard a noise and looked over in the direction where they thought the noise came from. They were two of a number of people who testified later they heard the noise. Oddly enough, and these were mostly all students, their reaction to it was, well, it must have been a car backfiring or somebody set off a firecracker or somebody's fooling around. They paid almost no attention. As a matter of fact, to the extent that a couple of witnesses who actually saw the deceased's body, the victim's body on the ground next to a car, thought he was working on his car. Shortly after the noise goes off, a car comes down that lane. The witness is positioned in such a way that he sees this car go by. Now the car's not racing out, skidding out like somebody escaping. It's just a car going at a reasonable rate of speed in the parking lot, leaving the parking lot. Now at this point he doesn't know that the noise he heard is gunfire. He testifies that he sees the person in the vehicle, who's later described as having facial hair, a beard of some kind.
A lot of these men who were in prison where the DNA evidence said they didn't do it. They couldn't have done it. They were identified by the victims as the guy who did it.
And as a trial judge, I always assumed when people were testifying that they were telling the truth as they saw it.
Victims are now saying, I was wrong. I can't believe I was wrong, but I was wrong. What happened? What happens is that we're human. And you know, if you show the same picture to 5 people and have them describe it to you individually, they'll give you 5 different descriptions.
You have to take into consideration what it is that might have jogged their memory or caused them to have a clear memory of it.
Within a couple of hours after having observed somebody leave the parking lot in a car, was subjected himself to hypnotism by a professor there at the community college, and claimed to be able to identify Fred Freeman as the person he saw driving from the parking lot.
He comes up with a license plate number, which when they trace it has nothing to do with the crime, has nothing to do with the defendant, has nothing to do with the type of a vehicle that he claims he saw that license plate on.
Just the fact that he saw somebody leave the parking lot in this vehicle just was not clearly indicative that this person was in fact the person that had committed the murder.
This is your eyewitness. This is really the whole thing that they have.
I originally learned about the crime from a friend of mine. I went to a gentleman named Paul DeVar's house. Paul got a phone call from a person named Dash Deals, a local friend of ours. And Dash told me at that time the police were looking for me.
Now he's going down to find out what it's all about.
There's a phone log from the 9th on that shows me calling the Flint police constantly. Not only did he say they had no information about me being wanted for any crime, he said We literally have nothing we need you to turn yourself in for. And I repeatedly offered to turn myself in at that time. And he said, you can turn yourself in if you want, buddy, but I've got nothing on you.
He calls her up at her home. Why are you charging me with murder? Talks to her on the phone for 2 hours or longer. While not only the parents are on the phone, the parents of the victims are present. They get a police officer there. He's on the extension phone upstairs. Didn't admit that he did it in all this long conversation.
Michelle was terrified from the very beginning. She basically had a SWAT-style assault, brought down to her head at the age of 17 years old. She was pregnant.
And slashed open the pillowcases, slashed open the mattresses. They completely went through and ransacked the house. During that time, he called on the phone. And Detective Bowns answered the phone, and he said, "You're wanted for the murder of Scott Macklem."
As far as I know, I've never met Scott Macklem.
The lead witness put on by the prosecution was a young lady who was a fiancée of the young man that was shot and killed. And she testified. She was on the stand for a couple of days, and I was shocked, frankly, at the testimony that was allowed to be received from this young lady.
I thought it was the most ridiculous testimony I ever heard in my life. It was like something out of a bad movie.
His conversations, as she testified to with her, were full of braggadocio about his abilities in the martial arts.
She portrayed him as a very bad person, an intimidating person.
She claims he raped her, although she didn't tell her parents. And the day after the so-called rape, he comes back into the store where he met her and asks to borrow her car, which she gives him.
Now that I studied law for all the years, I realize that 99% of what she said is not admissible.
Fred Freeman was able to collect what we refer to in loose terms as a harem. He had a bunch of women that would do almost anything for him.
I can't see being a jury member and believing a single word she said. But Mr. Dave made very little attempts to object to her testimony.
And on the other side was the testimony of a woman in Escanaba, Michigan, a member of the board of directors, or perhaps secretary of a corporation of which her husband was president, who testified at the trial that on the day of the murder, she spoke to the defendant in Escanaba, Michigan.
I met with Kathy Dyer, who was running the Wednesday class at Taekwondo school, so she was sure. Mark Sherman had been there that day. His daughter had I believe a school recital of some kind, so he was sure that he had seen me. So most of the witnesses had some information to confirm for them when they had seen me.
And incidentally, after she had the conversation, the owner of the establishment came in and also talked to the defendant.
Well, he showed up at the beginning of the class, so it was about 11, right when we would have lined up. It sticks in my mind because that day when Fred came in, we were discussing the practicality of the jumping back kicks. And I was wearing blue jeans at the time, and we were discussing whether or not Chuck Norris was really doing it, and we found it very difficult to do those techniques with blue jeans on.
Mr. Freeman's girlfriend, who lives in Escanaba, was prepared to testify that he was with her at the time of the killing. And she was never called as a witness. And I don't think there's an explanation for that anywhere in the post-conviction materials or anywhere that I saw. Why wasn't she called?
She could not only have testified about the fact that he was in Escanaba at the time of the killing, but she could have testified with respect to the relationship that really existed between the young lady that testified in the initial part of the trial and Fred Freeman himself, that it was not the kind of relationship that she portrayed it to be.
She would start coming over like every day, and she would get really nasty with me. I mean, I want to talk to him now. I mean, like demanding. He's just like, tell her to leave. Tell her I don't want to talk to her, And he wouldn't get up and talk with her.
Now, there's also allegations that she has since made that she was threatened by the police to stay out of this case.
They threatened my witnesses. They threatened Michelle until she ran away. She was terrified. She was angry at me because of this whole mess had been brought down on her head, and she was afraid of the police officers, and she was afraid for our child, and they had threatened her. They told her they would take our child away. They took our dogs. We had 2 puppies. They took the dogs from her to the shelter, and then when she went on to the dogs the next day, they told her we destroyed them already.
Detective Hudson, he, like 3 or 4 times he came to my house and was like I don't know if I was just a really scared person or if it was him, but at that time he began to be intimidating to me, and well, he did it, why don't you just admit it?
Those kinds of arguments are typically fruitless, because you simply can't prove that the police did anything wrong because they're not going to admit it, and if it's just her word against the police, they're going to believe the police. But that still doesn't explain away why she wasn't called as an alibi witness, and that I think is real critical.
Police who cross the line have qualified immunity, and that qualified immunity is being interpreted in ways that really embraces and covers a lot of misconduct that shouldn't be sanctioned.
I had a polygraph scheduled to be taken in the month of December when I was still in the St. Clair County Jail.
Polygraph examinations are used by law enforcement as a tool. Many times when a person takes a polygraph, when they're confronted with the fact that the polygraph examiner failed them, they'll confess. Many times, though, people who are truly innocent fail.
For the little bit that I know about polygraph, a person with no conscience could pass it.
They're inherently untrustworthy.
They can't be used as evidence in court.
The day that I was supposed to come for the polygraph, the sheriff himself came and told me that John Bowns and Robert Cleland had the polygraph canceled and that I would not be getting tested. Officer Bowns is, he's your prototypical crooked cop. He was involved in drug running. He was accused of involvement with the mob. Numerous drug dealers would come forward to say that he would literally beat them and take their drugs, take their money, take their jewelry, hustle them, have them sell drugs for him, and when they outran their usefulness, he would have them busted or bust them himself.
With the questions he was asking, he was after what he wanted, and I don't think the truth came into it.
I couldn't believe that things like this would even be brought up in a court system. Different things like asking about American Ninja 3, if I've ever seen these movies.
And so everything was to try to show that, well, we know this guy committed it, and now how can we prove it? And that's why you got into this goofy thing like, well, he's got a good alibi, but there must be some way around that alibi because we know he did it. And now let's figure out how he could have done it if the alibi is true.
I believe that between the numerous witnesses, the evidence showing that I was in Kmart's with my vehicle broken down that day, the receipt showing that I bought parts for my car at Kmart's, the evidence that I was at Ponderosa and Big Boys the night prior to the morning with my car broken down until the early morning hours, I believe should be more than sufficient for the average individual, better yet for law enforcement.
I'm confident that we have the right person in jail. We had information from the landlord that indicated that this person was involved in some unusual activities in regards to some martial arts and things that fit with the statements we got from the girlfriend of the victim.
The defense lawyers representing guilty people can expose police and prosecutors who are breaking the rules. Then when the innocent are charged, they're fair game.
There were elements and claims in the courtroom and the laying out of guns.
There was never any of it connected to the defendant.
Were any of these things your property?
No, sir, none of these are mine. I do have some martial arts equipment, but they didn't seize anything that was mine. They went out and got their own stuff.
The whole approach of the prosecution was to try this individual as a bad guy. And I must say in that respect that the defendant was his own worst enemy.
Fred Freeman, in my opinion, is probably the most dangerous person I've ever come across. I've been in this business since 1981. I come across some real bad people. He's a Charles Manson type.
They had a subject. They had an individual who had proven himself to be a hothead. In this case, maybe one step from an asshole, and was the kind of person he was back then. And so, he was confident, he was arrogant, he was all of the things that I guess made him kind of the automatic green light subject.
He was good. He did a wonderful job as a prosecuting attorney.
They would literally put me in full shackles, legs and wrists, and then take me across the courthouse parking lot while the jury was walking in.
If you're in the legislature, if you're a prosecuting attorney with strong ambitions, the scorecard means a great deal.
There were lots of people who wanted bigger, better jobs beyond this case.
Well, his court-appointed attorney is a former member of the St. Clair County Prosecutor's Office.
He was a prosecutor for St. Clair County, which I was never told. And he had been prosecuted for drug use in 1983 in Ohio.
He's had drug convictions. He's been housed in rehabilitation centers.
He had other drug charges during that period also and was on drug probation at the time that I met him.
I believe that there wasn't one stone unturned, one legal issue that came up in that trial that I wasn't prepared to argue legally and hadn't researched. I wasn't surprised at all.
He's had a number of clients that he represented who were found guilty that had their court case reversed because of inadequate representation.
I don't care what people say or their opinions.
The ineffective assistance of counsel, I think, in this case goes deeper than what you can see on the record. The fact, for example, that this defense lawyer had also been the lawyer for the chief investigating police officer some time before this case, which would give him sort of a classic conflict of interest.
He's best friends with everybody in the court, and he has to endear himself to these people. This is where he lives and works, and he was not going to rock the boat for anybody, especially me.
When we have defense lawyers that are totally incompetent or underfunded, who do terrible jobs, you know, the courts are ready to sanction that. Nothing guarantees the conviction of an innocent person faster than a lawyer that's not up to the job.
In this case, the lawyer was hired by the defendant or retained by the defendant before he was appointed by the court. His name was given to the defendant by the sheriff in the jail. Here's a good lawyer, you ought to get this guy. Then he goes to the judge, I got this case, will you appoint me to represent him? It's a very bad process, a very bad system.
We now know, and I think it's a matter of public record, that the defense attorney in this case has been suspended from the practice of law. At the time of this trial, apparently he had a serious substance abuse problem.
This trial really got to me. I spent a lot of time, a lot of work. I was crossed between innocence and guilt.
He owned a bar called Wall Street in Port Huron, and he would visit me drunk. And all the time. I mean, just out of his mind. His eyes were glazed. He was always high.
I'm not so sure this wasn't the reason for it. I mean, I had a breakdown after that.
He told me he was having heart problems. And then I asked him, you know, what's the cause of these heart problems? He said, oh, we're just partying too hard. You know, that's what it came down to. He didn't really discuss the cocaine personally, but then later on, you know, he made it clear that he did use drugs. And I have a big ethical problem with drug use, of course, which a lot of my witnesses testified about. I'm very anti-drug. I always have been.
They can't cross-examine people, they can't do an investigation. That's why these bad crime labs, where there's been outright fraud, existed for years, because the defense lawyers, you know, were not trying to seek the underlying data, not getting experts, not up to the job, not smelling a rat when there was one obviously in the room.
One of the things that we often see with lawyers who have substance abuse problems, who keep trying to do their jobs, is they lose attention to detail.
He had an assistant, Jan Barnum, who did a lot of work in the case. She did an incredible amount of work, and 90% of the good things that she did, he didn't use either. She framed incredible questions, like you're asking me now, and for the courtroom, and he never used any of them.
Now, does that mean he's entitled to a new trial because his attorney was on drugs or was drunk? No. Sometimes attorneys who are extremely drunk can do a pretty good job. The real issue is, as a result of what his attorney did or did not do, was he denied a fair trial? Was he denied the right to have, his absolute right to have the jury consider all the evidence in his favor? And I don't think they did. I don't think the jury got to hear all the evidence in his favor. And that bothers me. It bothers me because it leads to the very real possibility that he didn't commit this crime.
I had assaulted a police officer and maliciously destroyed a police car, and you know, I was just wild and out of control. I spent the majority of my time in the St. Clair County Jail in L cell, in segregation, because I was combative. I wasn't jail material. I just didn't get along with the other prisoners, and I couldn't handle it, and so I did better in segregation. I ended up next to Fred Freeman. That case was on the news every single day. Every radio station on our radio, because we had a portable radio in the cell, every 15 minutes they were talking about the Freeman case. And I found it kind of intriguing that I was locked up next to this guy, and he adamantly said, I didn't do this. I had nothing to do with this. I was 400 miles away from where this happened when it happened.
Oftentimes you get these cases where the prosecution doesn't seem to have much evidence against the defendant, and then at the 11th hour they come up with some goofball who was in the jail with him, who has a criminal record as long as your arm, and who says, yeah, well, he told me he did it.
Yeah, I said that he shot this guy with a shotgun. You know, prosecutor's office told me that when I made that statement to make sure that I turned towards the jury and looked at the jury.
The term of art is jailhouse snitch.
Mr. Joplin asked me some questions about my case, and all I told him was I didn't do it and that I was innocent, and that I thought I would prove my innocence.
Every time I see a conviction based in whole or in part, in large part, on a snitch's testimony, the flags go up. There's something stinky here. And in this case, I think without that snitch's testimony, a powerful argument could have been made that the jury would not have convicted Fred.
There's something in it for him to lie. There's an advantage for him to lie.
What typically happens, the real scenario is, two guys get stuck in the jail together and they say, hey, what are you in for, right? You know, you can see it in a TV show, hey, what are you in for? And so Mr. Freeman likely said, well, they said, I'm accused of murder, I'm accused of killing this guy, but I didn't do it. Oh, really, what do they say you did? Well, they said that I did this and that. Oh, next thing you know, he's calling the police officer and saying, he told me he did this and that.
Did Mr. Freeman ever say that to you?
No.
Did he ever say something about the victim screaming when he shot him?
No.
Did he ever say he used a shotgun to kill somebody?
No.
I was unbelievably shocked. It was an insult, of course, just thinking I was so stupid I would even do something like that. To spend all my time telling anybody who would listen that I'm innocent, and suddenly to come forward and say, oh, but I'll tell you that I did it, and plus I'll tell you details about it, and that was, that was very shocking.
So why did you write in your letter that this man was a confessed murderer?
To see if it would get me out. You know? I mean, I heard of it happening before, but I'd never seen it happen. You know?
I was approached by two gentlemen. I believe one was Elwood Brown, and the other one, I believe, and I can't be for certain, was Robert Cleland. They wanted to know if I could provide them with any information regarding Frederick Thomas Freeman.
Somewhere along the way in talking to the police and the prosecutors, they asked you to say and do certain things.
Yep.
And you decided somewhere along the way that you didn't think you wanted to do that.
Yeah, it was after I'd been after they had snatched me out of here. About 2 weeks after that, after I'd been going through all this thing with them, I wanted to back up out of it.
And what did they say to you?
They got very mad and upset about that.
Do you think that the officers involved, were there certain people who were putting more pressure on you to do this than others?
Oh, definitely.
And who were they?
The main one was a parole officer. You know? Used to be my parole officer.
A prosecutor who deliberately commits a crime by suppressing exculpatory evidence is absolutely immune from prosecution.
If you testify against a suspected murderer or accused murderer, and the jury convicts that guy, and you're the jailhouse snitch, you're going to get amply rewarded.
I got the impression that they would have cut me slack as a prisoner that was willing to say that he confessed to me. That was the distinct impression that I got from these two gentlemen.
I've actually had clients say to me, look, I'm guilty. I did it. But that guy in the jail's lying. That pisses me off. And you know, it's kind of funny where they're willing to admit to me they're guilty. They know that, you know, it's privileged information. I can't tell anybody. But it bothers them that this creep in the jail is lying to get some kind of favor with the prosecutor. And they get their favor.
I guess to be perfectly honest with you, at the time I didn't really care. And I think they should let the guy out because he didn't do that.
If he had given me any indication whatsoever that he was responsible for that murder in that situation, then I think I would have.
Some states, not Michigan, but other states, have rules that say if the prosecutor's only witness on an element of the crime is a jailhouse snitch, a paid informant, or a co-defendant, that evidence has to be corroborated by other evidence or it's not admissible. Michigan doesn't have that rule. So people could be convicted solely on the testimony of one of these guys from the jail. The other problem, though, is this business about a deal. Is it legal for the prosecutor to make deals with witnesses? Absolutely. They do it all the time. But the law requires that if they make a deal with a witness, that deal be put in front of the jury so that the defense can argue to the jury, hey, before you decide whether or not you want to believe that guy from the jail, think about the fact that he was given a hell of a prize for his testimony. His testimony was bought and paid for. Prosecutors don't like defense attorneys to make that argument, so prosecutors have figured out a pretty clever way around this. They don't make deals with the witnesses before the trial. The witness comes forward and says, hey, I might have some testimony, I might have some information for you on that Freeman case. Prosecutor says, okay, what do you got? Well, what's in it for me? I can't promise you anything. My boss won't let me, or that's our policy, or whatever the reason may be. I can't make any promises. There's no deals. But after your testimony, we'll talk. Now, most snitches say that's good enough for me. If I give him what he wants to hear, they're going to take care of me. So the snitch goes into the trial, testifies. The defense attorney on cross-examination says, have you been promised anything in exchange for your testimony? And the witness very honestly answers, no, not a thing. Making it sound like I'm doing this out of the goodness of my heart because this guy's guilty and I want to see justice for this poor dead person. Baloney. He's doing it because he knows the prosecutor's going to reward him handsomely.
He shouldn't be in there for something that I said.
He seemed genuinely relieved by the fact that he finally could tell and say what was true. What was disturbing was the fact that he knew he was saying and doing the right thing, but he also knew that the prosecutors could really care less. That he needed to reverse the wrong, but the wrong would never be turned back. It's really tough for someone who was trained as a law enforcement officer, who knew something about investigation and police administration, to have spent all those years as a reporter chasing what was true, to have exposed what wasn't, and to know what wasn't true put a man behind bars for life, and to know that even after we expose that, he's still there. It's painful.
Snitches, these jailhouse snitches, they always have criminal records, and we know this guy had a criminal record. The defense attorney has the right to bring that record out in front of the jury to attack his credibility. So you've got different bases on which you can attack the credibility of this kind of a witness. Number one, he's bought and paid for. Number two, he's sitting in jail and you know he's looking for a deal. Number three, he's got a criminal record, and one of his prior convictions was bad checks, uttering and publishing. That's what we call passing a bad check. That's a conviction which reflects upon the felon's dishonesty. So this guy is a dishonest character, and he's basing a lot of his testimony, a lot of the conviction of Fred Freeman, I'm convinced, is based on this dishonest testimony, or excuse me, the dishonest character who gave the testimony.
They pretty much thought that he was here, and they said there's physically no way he could have went from here to there or there to here in that amount of time, but yet he still did it.
The defense attorney did present evidence at trial that 2 hours after the killing in Port Huron, Michigan, Mr. Freeman was seen by a large number of people in Escanaba, Michigan. And by car from Port Huron to Escanaba, if you're breaking all the speed limits, you might be able to get there in 6 or 7 hours.
The prosecutor brings in a police pilot, and he testifies that you can fly from Escanaba to Port Huron in a small airplane in about an hour and a half or whatever it takes.
But I'll guarantee you, if this prosecutor was even doing half of the work he should have done to prepare for this trial, he went out to the airport. We're talking the Port Huron airport, small little airport. He went through all the files. He had his people out there, his officers out there, going through everything, talking to every living soul at that airport. Now guess what? No record of this fantasy flight.
At trial, you have to understand, neither Fred nor I knew that the prosecutor, until rebuttal, the very last chance, we don't have a chance after him speaking, he brings up this theory that Fred had someone fly him down here. And of course there was no evidence during the trial or anything in the police reports to indicate that in fact that ever occurred.
Now, why would he bring this testimony in, except for one purpose, as he makes clear to the jury, that it was possible for the defendant to have chartered an airplane and flown down, had somebody meet him with a car, go and commit this crime, go back to the airplane and fly back up to Escanaba by noon so that he could walk in and have a casual conversation with somebody at a martial arts studio.
But they never showed you a pilot.
No, sir.
And they never showed you a plane.
No, sir.
And they never showed you how it really happened.
No, sir.
If, in fact, there was any paper trail of this flight, if, in fact, it actually happened, the prosecutor would have been able to prove it.
There were no credit card charge tickets showing that he hired chartered a flight.
If he had any indication, any piece of paper that said Mr. Freeman chartered a plane at any time, because if Mr. Freeman had chartered a plane a week before, if I was the prosecutor, I would have brought that evidence in. See, look, he knows how this works. He's done it before. Probably testing it out to see if it will work the next time. No record he's ever done it.
I mean, even if somebody had said, I'm a pilot, and the defendant called me and asked me what it would cost to fly him to show that maybe somebody in Escanaba was in the market to hire an airplane. I mean, anything. Not the slightest bit of circumstantial or any kind of evidence to connect him with an airplane.
What he's really claiming is that the only way Mr. Freeman could have committed this killing was to get a plane illegally, without any record being made of it, take off from a field somewhere, not an airport, so there'd be no record, land in a farmer's field somewhere in Escanaba, so there'd be no record of it, hang out in Escanaba with all of his friends, and then get the plane back to Port Huron before anybody missed it. This is nuts. I mean, I want to say this is absurd, this is ludicrous, it's nuts.
It is the most preposterous, incredible, unbelievable story.
This is the prosecutor's fantasy theory, which rebutted one heck of a good alibi.
He was obviously very articulate. His lawyer certainly knew that. He'd make a good witness.
Coming to the end of the trial, I wanted to testify very badly. I wanted to counter these claims made against me, of course.
So all of this evidence that had come in about what kind of a person he was allowed to stand without any rebuttal on his part.
He told me there's some court rule saying that I can't testify when everybody else has testified because it looks suspicious or some silly thing like that.
The only thing I could have done on hindsight is I would have forced Fred Freeman to take the stand.
I think that I remember him saying that he made the mistake of not letting him take the stand himself.
And that was a mistake, but it was a decision we both made.
If you believe that your client is innocent, you put your client on the witness stand and let him testify.
I wish they would have put him on the stand to really understand it. I don't know why they didn't.
I'm like, wait, tell the judge I want to testify. And I made a big scene about this. And he wouldn't do it and I wasn't allowed to testify. Then he told the court that I didn't want to.
It's difficult for a judge to give an instruction to a jury that says, take that out of your mind. We know you think that if he was innocent, he would have taken the stand and denied it. You know, some of the jurors said things like, well, he didn't take the stand, you know, and that.
Exactly what we fear.
Exactly what we fear. They're told not to think about that, but that's what they thought. If a defendant doesn't testify, there ought to be some sort of a court rule that says they ought to get it in writing.
He has a point that I had the obligation to advise him that he had the right to testify.
I believe that there was a conspiracy. I'm amazed that a jury could vote, a large number of jurors, more than half could vote in my favor, and then come back on Monday morning with unanimous guilty.
They did do some interviewing of jurors which indicated that, first of all, that there was a very deeply divided jury when they first voted on it.
You know, the jury found that he had committed the crime beyond a reasonable doubt, and of course I accepted it, as I did every jury verdict that I'm aware of.
Had I been the trial judge, I think I would have directed a verdict for the defendant. I mean, I think there was really not enough evidence to let the jury even hear the thing.
It's a first-degree murder case, and it's made it all the way through the Michigan appellate system, and no one has paid any attention to this case.
Right now, we went to the trial court to try to get a new trial last December, and in January we were informed by the trial court that they had denied his motion for a new trial. So the next step was to take it to the appellate level, and that was the Michigan Court of Appeals. Went to the Michigan Court of Appeals. We were informed that the Court of Appeals turned us down. So then the next step is to go to the Michigan Supreme Court.
In Michigan, there's only one way to get back, and that's what we call a motion for relief from judgment. The shorthand is a 6,500 motion, and that's simply because that's the number of the rule that promulgated that procedure. It's a very narrow procedure. If you want to come back, you got to go over some big hurdles. Number one, you can't raise any arguments you raised before. They got to be all new arguments. Number two, you have to show good cause why those arguments were not raised before. You have to show that if your attorney would have raised these arguments, you would have won your case. So that's cause and prejudice, we call it.
Hopefully the Supreme Court will see the light and give us a new trial, or at least give us an opportunity for an evidentiary hearing back in the trial court.
I don't expect this motion for relief from judgment to be successful.
The next step would be to go to the federal court in a habeas corpus proceeding.
His lawyers have to convince a federal judge that the prosecutor in this case tried the man and not the facts of the case.
You've got to convince the judge that we have a good reason to be here, Judge. You've got a big problem with this case, and you've got to give this guy one more day in court.
He is now the colleague of the judge who will be hearing that habeas corpus. He's a federal judge. And it's just not going to be real easy for one federal judge to say that another federal judge did a bad job when he used to be a prosecutor.
All right. So what did I tell you right at the beginning?
Let me see if I do things.
On the morning of November 5th, 1986, were you in the parking lot of the St. Clair Community College when Scott Macklem was shot?
No.
It clearly shows me that Mr. Freeman did not shoot Mr. Macklem.
Thank you. He passed the polygraph, and I just immediately and continue to shake my head. I just had this very strong feeling that this was a system that wasn't going to give up.
You know, we have to do something about the laws that prevent effective civil rights suits against police and prosecutors. There's a lot to be changed in that law, and frankly, it's going in the opposite direction.
It's outrageous to me that people go to prison for crimes they don't commit. Most Americans like to think that doesn't happen. It happens, and it happens in large numbers.
Race and class have everything to do with how much justice you get in our system.
But if you don't have an enormous amount of money, you're going to get consumed by the system. It's going to eat you up. It's going to chew you up and it's going to spit you out.
Fact is, if we adequately funded the defense, if we had our crime labs as independent entities that were not tied to police or prosecutors or the defense, but just independent scientists, call it as they saw it, this system, this adversary system we have here in America, where in theory we are dedicated to due process, procedural due process, substantive due process, equal protection, would work brilliantly.
Prison population is just escalating continually.
Mistaken eyewitness identification, false confessions, bad forensic science. My gosh, there's so much of that.
What we do have in this country is what I call the court of last resort. And this is it. If you get a case where there's a celebrated miscarriage of justice, and it's on 60 Minutes, and it's on this, and it's on that, on television, it's written about in the newspapers, and reporters are demanding what's going to be done about it, and the governor's office, and the whole sort of thing. The judges, they know about that. I mean, they don't live in a cocoon. And I think that more than anything else, that is, it is the last resort.
Quite frankly, I had a bit of a confrontation with the governor of the state of Michigan. And then immediately after that conversation, it appeared that Ken Sue's relationship with the people that run the prison where he's in started to go downhill. Immediately there were tickets, there was pressure, there was threats, there was putting him in holes and all this kind of crap. And so we've now gotten an attorney involved, and so we're really concerned about his life and limb at this point.
What he said was that my own attorney was involved in drug dealing in that town, along with Mr. Drennan and the victim, Scott Macklem. Mr. Macklem had a lot of money, his family had a lot of money. His father owned State Farm insurance businesses. I believe he had some involvement in Vlasic Pickle. I know he was the mayor of Croswell. And 99 knew all of this. He knew about all his financial information and personal information. He knew about Scott's father being the mayor of Croswell. Now, bear in mind, 99 is not from Croswell. This is the person from Detroit. And he had all this information about this young white kid from, you know, a small farming community. The story he told us basically after a lot of digging, because he didn't want to confess, was that You have 1 minute left. He was actually involved with Dan Grennan in arranging and orchestrating this murder, which Dan Grennan committed, literally claiming that Dan Grennan killed Scott Macklem to shut Scott Macklem up because they were afraid Scott Macklem was going to talk about their drug dealing. And he also claimed that my attorney was personally involved in the setting up of this murder, and that he knew about it, and that's probably why he sold me out at trial. So that was the bombshell that was laid in our lap.
This new development, if it turns out to be what we understand it might be, might make all of the legal proceedings moot, we would hope. But I've gotten a little cynical about the way things go in this system, and we'll see. We'll just have to see how it works, how it goes.
We must be able to evaluate his credibility early on, and then we can determine later on how reliable his information is.
If this information turns out to be true today, then we really have some dynamite information. So we're on the edge waiting.
My wife died 10 years ago this month, and it was before she died that I was working on this case, so it's been more than 10 years.
He was a member of a very large, very powerful gang. He was actually an undercover informant that did work for the ATF and the Secret Service. That he'd done time in federal prison, that he had been housed with some very powerful mafia and gang figures, and that he had been tied to groups such as the Young Boys. The amazing part about this individual was he got every name right. He got the background information right. He recently identified photos of all these players correctly. Grennan pulled, if this is true, what's called a sleeper move. You know what a sleeper move is? When you convince somebody that you have a problem with, that you don't have a problem with them anymore, so you become friends again and get back into their confidence. According to him, the morning of the murder, they were actually all together using drugs, and Scott was going to the college to sell some cocaine that they had packaged up, which 99 personally witnessed them package up. When Scott was killed, according to 99, there were drugs with him in his gym bag. And as we know, John Bowns got to the scene and John Bowns got to the gym bag before anybody else.
He's an individual that was a player in the drug trafficking at that time. Okay. And he had a very, very close relationship with individuals that were in law enforcement and the criminal justice system. Mm-hmm. And based on in Port Huron. And based on his information related to us, there was a significant amount of corruption. Historical documentation has identified the Port Huron area as being one of those locations where, you know, whiskey and alcohol was being brought into the United States during the Prohibition era. There was the same kind of money being made there in the 20s, relatively speaking, as what is being made in drug trafficking. Not only in Port Huron, but in other parts of the United States that might be ports of entry or areas in which the drugs are brought in.
For the first time since I've known him, he's scared. He's worried about his safety. He's worried about the future that he's been fighting so hard to essentially reclaim.
Something there that's worth continued contact, and certainly there are leads that can be covered.
There's a lot to follow up. There's a lot to consider. There's a lot to evaluate. It is unfortunately going to take stepping around in the mud, in the sewer. We've always known that David Dean had personal problems with substance abuse and the law. Now we are being told that his personal problems with substance abuse has much more to do with his consuming. It has to do with his being in bed with people who distribute. And although we can't claim at this point that David Dean was himself a distributor, we can certainly say that his use and being in bed with people who use and distribute made him a player, a direct player in the killing of Scott Macklem.
As far as those individuals are concerned, I believe that the murderer could walk in with a videotape of him or herself doing it and a gun in their hand and photographs, and he'd still say I was involved in some way. They're never going to admit they were wrong.
There's a wrong-headed notion that if you admit the truth, you admit that somebody was wrongfully convicted, and you face the fact that maybe police suppressed exculpatory evidence, didn't play by the rules because they really believe they had a guilty guy, or worse, that somehow the legitimacy of the system will be undermined.
Change, you can't rearrange me.